number 124, Ferrara versus Peaches Café. Counsel?
Thank you, Your Honor. May I reserve 1 minute?
1 minute?
Yes.
You may.
Okay. Thank you. Your Honors, Justices, may it please the Court, I'm Gabrielle Hope, and I represent the appellant Core, Ridge Road Company, LLC. I want to thank you for agreeing to hear this on our petition. These issues have been, I believe, fully briefed, and I think the thing that I would like to talk about is that there are what seems to be two lines of cases causing a split among the departments. In the first, second, and third department, it appears, at least from all the case law that I've discussed and read, that in order to foreclose a lien against a non-contracting owner, there has to be more of a direct consent.
Where does that line of cases originate from?
I believe it around 1901. I think the first was DeClin, where it started to discuss that. Then followed up with Rice versus Culver. I think that it was more expanded in Delaney.
Okay, so in Delaney, was there a lease that authorized any improvements?
I think that was factually that was a different situation.
Okay, and so in that case, the court looked at other indicia
Yes.
of consent, correct?
Yes.
Okay. And, okay.
But I think Rice is where the court comes out and says that, you know, this is, in fact, Rice is the case that came out with the rule of law saying that in order to hold consent, the owner had to either be an affirmative factor in procuring the work or having possession and control have required the work to be done. It's an or test.
Let's go right to the lease and the provisions in a lease.
Yes.
What about the provisions? What about them?
Oh, okay. In this lease, which is very common in commercial leasing these days, you know, does the owner keep some authority in the lease in the event of a contingent problem where they have to execute on that authority? Yes, they do. That's very common. You have to have some type of contingent authority, again, in case something goes wrong. But in this particular lease, I think if you read the whole lease, what you'll see is the purpose of CORE's review of the plans and specification is to, one, assist the tenant to the extent they need assistance with what they're doing, and to make sure that what they're putting out is in conformity with the rest of the shopping center.
Well, what's the relevance of the purpose of it? And clearly, in the lease, the landlord, it's their property, it's Core's property, right? And for whatever reasons they have, they want to be sure that things are done in a certain way. Part of it has to do with consistency, part of it has to do with the fact that it's their building, they don't want anything to harm the building, right?
Correct.
Okay, so all of that. So what more, if a lease were ever to indicate consent on the part of the landlord, what more would it have to say here?
Well, I think that it would have to, I think there would have to be some evidence that the owner would be willing to pay for these improvements or step into the shoes of the tenant. Because in this particular lease, there's an RCE, or a retail construction exhibit, which really...
Why would a landlord ever say that?
Well, why would they well, some of the cases that ultimately were found where there was possible renegotiation, where the landlord says, okay, yes, we will pitch in on this. Certainly some of the cases that I cite where it's almost like an equitable thing. The tenant is doing a build out of a shopping or a department store. And he goes to the landlord and says, will you pitch in $60,000? And the landlord says, well, let's see how it goes. Maybe I'll give you 15 if you do all these other things. You know, so that is a different
But is
situation.
that consistent with the cases like Jones and
No.
McNulty?
No,
and-
but
okay.
I think that's where, but on that particular case, the court came down and said, yes, there's an issue here that they likely consented. And I also think that it was an equitable situation in that particular case because of what the landlord was doing. The landlord was trying to exact additional things out of the
So let me
tenant.
ask you this. If you've gotten a lease and indemnification clause, does that suggest that the landlord anticipates that they're going to be liable, and so they've just made that arrangement with the tenant that the tenant is going to pay?
Yeah, I think what it does, and this one does have one, and it also has the lien, the
Yes.
normal lien thing.
Right.
I think what that does is show the owner's lack of consent to paying the tenant's bills. Because I think maybe I didn't, I don't know. But,
Why couldn't that also show, we have a particular arrangement, the landlord is now responsible under that arrangement, recognizes it so, but is shifting the costs to the tenant, that's part of their negotiated arrangement? Why couldn't it show that?
Well, I think that if you put it in with the lien language, that it abrogates that. I think between the two, what it's saying is, no, we are not paying for this. And particularly in this case where there's a real delineation of, we're going to do this work, and we pay for this work, and you're going to do that work, and you're going to pay for that work. And when you have something really set out that clearly, to keep in mind, the freedom of contract between a landlord and tenant, they can really, as long as it's a legal contract, they can do whatever they'd like, whatever works for them.
Including the landlord could have insisted upon a provision requiring the tenant to have a letter of credit or post some security or something just in case the landlord
They could have
ended up
done
being
that.
responsible. So,
They could have done that.
So the landlord, there are ways that the landlord can protect themselves.
They can, but now, where this is going to hurt people, okay, so, as I was going to say, the agreed upon, when a landlord and tenant get together on a build-out, they have to decide, okay, how much are you going to pay on a monthly basis? And all these calculations are put into this. So in this case, they say it's $8,000 a month. Now, if CORE had paid for all the work, then they could do that, they could have agreed to that as well, but the lease price would go way up.
I'm not sure whether you're arguing that on the face of the contract as a matter of law, you have not consented, or you're saying there's a fact issue here about whether this constitutes consent and there's extrinsic evidence necessary for that.
I'm saying that as a matter of law, we did not consent. I am saying that when you look at these general approval type provisions that the Fourth Department looked at, which I believe has been somewhat rejected by Rice, the general approvals that you just see in leases all over the place.
And so regardless of, for example, the daily visits or direct communications with the architect, things that are ex-contract, you're saying none of that is relevant, that's all, because the contract is clear on its face, that's it?
Well, Your Honor, the communication between the tenant's architect and CORE,
Yeah.
okay, that had nothing to do with the plaintiff Ferrara. That occurred in the beginning. CORE had to look at the plans to make sure that things like the HVAC system complied with the rest of the building, the rooftop penetrations, things that they were paying for under the lease, and it's a roof over several parcels. Okay, so, there's certain things that they have to look at from a structural perspective.
But why isn't this a question of fact, then? I mean, if you're saying there's language in the contract, there are certain actions which are parsed through in great detail in these briefs, why isn't this just for a fact finder? Why, as a matter of law, should we find you didn't consent?
Well, because I think that the only thing that we have here in favor of finding for Mr. Ferrara are the general consents in the lease, which in most cases were not executed upon. While, like, for example, CORE had the ability to approve the contract.
But it seemed
they
like
didn't.
it seemed like the consents were very detailed. They were approved by an agent of the owner. They outlined extensive work that that had to be approved for both the plans and the specs throughout.
And it never happened, Your Honor.
I'm talking about the lease, though. The lease
Yes.
did seem to outline them. there's an underlying policy consideration that, before your time's up, if you could just address briefly, one of the things I wonder about is whether or not, in this situation, the landlord gets the benefit of the work done on their property. In essence, then, if somebody sets up a business like Peaches goes belly up, the landlord gets the benefit of the work without paying for it, and there's no recovery available for the person that actually did the work under your theory. In essence, once they leave, the landlord gets all of the work that the electrical contractor did and doesn't have to pay for any of it.
Not necessarily. I mean, I think that if...
How not? Tell me
Okay,
what I'm
if-
missing.
Let's say, for example, that the premise, okay, because Peaches, the thing was, it opened in January 2009.
Mm-hmm.
Peaches was evicted in 2013 for failure to pay rent.
Mm-hmm.
They owed Core $147,000.
But there were only 50,000 that was still left in dispute, right?
Yes, there's 50,000 left in dispute with
So,
Mr. Ferrara.
so assuming that's true, how is it that the landlord gets the electrical work, in theory, that could be used for another restaurant, because most developers in this situation are looking for a restaurant, and it has all that electrical work done, but doesn't have to pay for it, because he's sheltered by Peaches acting as a pass-through. Yet he approved it, made sure that it fit the needs that he thought fit in with the work that had to be done for that place, and it fit in with the other developments.
Peaches, you mean, approved the work? Because Peaches
Well,
set up his
the
kitchen.
landlord's agents approved had to approve the work per the lease. So how is it that this theory, the policy implications of your theory are that the landlord gets basically work that he didn't pay for? He gets the benefit of it.
Let me try to answer this, and I know I'm out of time here. I think in this particular case, the only things that CORE actually approved, while there was broad approval rights under the agreement, they were not done. So they approved the transformer, which CORE paid for, and they approved the HVAC work, and that is all they actually approved of. The kitchen work, the guts.
Talking about the finished work, because I thought they approved all the plans all along the way.
No, they approved the preliminary plans. Okay, so in the beginning, before this all starts, Passero, the architect, sends the preliminary drawings, and they say, okay, except we need a,
But you understand my underlying...
I do.
My underlying policy...
I haven't answered it.
Yeah, I'm a little unclear on the answer, yeah, so it's all right. So the underlying policy concern is we're making a rule for the state now. And that rule would be that the landlord could approve plans, require the plans for his lessee, and then the lessee goes belly up, and the landlord keeps all the improvements and doesn't have to pay for the improvements that were done on the property.
Okay, now, but that isn't what happened here, and I agree with you.
That would be the rule that we would be promulgating should you be successful.
Okay. The focus, the amount that's subject to the lien, okay, is not part of what CORE approved. Because, and this is where this case is a little bit different. Mr. Ferrara entered into a contract with Mr. Scanio of Peaches.
Mm-hmm.
And it was on a time and materials basis where Mr. Scanio was in charge of approving the work. He wanted to tweak things as he wanted to. And Mr. Ferrara testified the only way we would do this, because the bid, he bid it out at $131,000 during.
I see what you're saying in that part of your
But
argument.
so they, so those two made an arrangement. Outside of CORE's knowledge, CORE was unaware of that arrangement.
I see. But all
And
right,
CORE
let
never-
me ask this then.
Yeah.
Would the lease here create a shield that would protect an owner from responsibility for work that the owner approved under your theory?
I think that with the lease.
Just generally, without, let me say it again. Does the lease, where the owner has to approve all the work, create a shield protecting the owner then from responsibility for work that was done to the property that the owner actually required or approved? Because a lien holder can't go after the owner if the leaseholder, or the lessee goes belly up.
Well, I think to the contrary, if the owner actually did approve all this work, like actually, approved it and did all of that, then that would open the door to saying, they approved of this, this, and this is the
So we're
focus of my
back to
lien,
the
but they
nature-
didn't,
So we're back to the nature of the approval then.
Yes, I think that when it's general,
I see.
and I know, and, perhaps I think the lesson to be learned is don't have this broad approval language in these contracts when you don't plan on using it.
Thank you, counsel.
Okay, thank you.
Counsel?
May it please the court, Thomas Fink, representing Ange Ferrara and Quillen Ferrara Electric.
Mr. Fink, are the lease terms controlling?
Prior Court of Appeals case said yes. Several Court of Appeals cases, and they're old, but frankly, they're still the law of this case until the court makes a different ruling, say absolutely that the provisions in the lease which require certain work to be done, where the owner agrees that they want certain work done.
What if the lease terms say, we require you to comply with the local building codes?
I'm sorry, Your Honor?
What if the lease terms say, we require you to comply with the local building codes? And that's in the lease. Is that then consent?
Just that provision may not be
Why?
sufficient.
Why not?
Well, I would argue that it would be, but there are
that's
some
okay.
cases which might
Which
indicate
is
that's
your
not
answer?
sufficient. In this case, on the facts of this
I'm sorry, I
case-
don't understand whether your answer was yes or no. Is it sufficient consent, under your theory, if what the lease says is, you, the tenant, must comply with the local building codes?
I think every tenant must comply with the building code, whether the lease says it or not.
But that isn't...
So I
my-
don't think that's necessarily, Your Honor, with respect, the necessary relevant fact in determining the decision in this case. I think what is required where the landlord
Because the
said-
landlord has, your point was, I think you're trying to say that since the tenant has to comply anyway, the landlord doesn't have control over that. The landlord can't say that you shouldn't and do not comply with them, or try and evict you if you are seeking to comply with them.
But in this case, the landlord...
No, but if that's what you're arguing, doesn't that fall on the side of the line of cases that say the requirement that the landlord may be held liable doesn't apply where it's not the kind of consent that the landlord can withhold?
But in this case, the landlord did require specifically the work to be done.
What if
No.
the work to be done, they said, you have to spend $130,000 on this work. Tenant goes out, contracts with the independent contractor, electrician, and they do $180,000 worth of work. Are they liable for $130 on the lien or $180?
If they require the work to be done, under most of the cases...
But let's say they
would be-
cap it at
They would be
$130.
required to provide to be responsible for all of the work.
But what troubles me about this argument is you can be required to perform certain work, and we can interpret that as consent. But then the tenant goes out and gets the gold-plated version of that work and does it all in a way that the landlord doesn't have approval on. And is there at some point a limit to how much that tenant can bind the landlord in terms of a lien for work that is, let's call it excessive, or above the amount contemplated that the tenant would have to spend on that work?
I think, Your Honor, that if the tenant went beyond what the consent was of the work to be performed, then the...
Sure, I guess my question is that going beyond what the consent is in my
Would be
hypothetical?
beyond it, yes, Your Honor.
So if there was a limit here, let's say they approved this RFP, which I think had a certain dollar figure to it, right? It was 130, I think, and I may be wrong on
Well, they
that.
actually, the credits from the landlord to the tenant was over $200,000 that they agreed
But
that
let's
they would
use a
as
hypothetical.
credits.
An RFP goes out, it's 130,000, but at the end of the day, the work performed is 180, and they file a lien for 180. The landlord had seen the RFP go out, but isn't seeing a daily billing cycle. Is the landlord on the hook for a $180,000 lien or a $130,000?
I think you have to understand what the work was.
And why
I
isn't
don't
that
think
a
it's-
factual question?
It is
Why-
a factual
So why
question.
isn't that not as a matter of law? Why is this a summary judgment issue?
The Appellate Division, Fourth Department, found the facts in this case. The owner agreed that this contractor would perform the work. The plans that, in terms of the electrical work, were in the plans, and that was all that was done. So in this case, the owner agreed to the work. I don't
The
think
owner
that-
had here somebody present during the build-out and could have, at some point, articulated some objection. You're exceeding the scope of what we agreed to.
Could have, and again, in this case,
Didn't.
they had an agent on site every day approving all the work that was done, and in fact, there was a letter by the by the owner to the tenant saying, make sure you understand that you can't change any of the work in the plans and specifications without our consent.
The both of you seem to be arguing a lot of facts here, no?
I would be happy to argue the law, Your Honor, because I think counsel has indicated certain cases that support her, and I think that's not correct. In Rice v. Culliver, which he thinks is her main case, where Rice, who did some plumbing work in a building that wasn't required by the owner, wasn't successful. But that's not the only lienor in Rice v. Culliver. There was the Frederick Company that took down trees and did some landscaping on this athletic field. And in Rice v. Culliver, while Rice lost, Frederick won, because in the lease, it said that the tenant had a right to take down some trees on this athletic
Can I
field.
ask you to clarify an answer to a question that Judge Wilson asked you? And I think he said, are the lease provisions controlling? And you said yes. But my question is, do you mean to say that you can't look outside the lease to other actions on behalf of the owner?
No, I didn't understand that question that way. I apologize.
Maybe I misunderstood, but that's what I had.
No, absolutely. In fact, all the Court of Appeals cases said it's not just the lease, but you can infer from the facts surrounding what occurs whether the work and the tenant was an affirmative factor in performing the work.
Right, but your position here, I just want to be clear, is that we don't need to look at the conduct because the lease is sufficiently clear to give us the consent.
No, I think all of the facts here in terms of the having a person from CORE on site inspecting every day.
So it's the
work.
lease and the conduct together lead to the conclusion that as a matter of law, the plaintiff gets his lien.
You know, the issue is, does the
That was actually a friendly question.
does the owner have to have a direct relationship with the tenant?
Right.
And I think there's
just so-
no-
To follow up on what Judge Feynman's saying is, you're saying that it doesn't have to be exactly direct. That's the way the case law, going back to Jones and McNulty, doesn't have to be direct, right?
National wallpaper, absolutely.
So
And
the
I
answer,
think-
so just let me stop you. The answer is yes. You
Yes.
agree with us?
Yes,
Okay.
I do.
All right.
And I think, Your Honor, I just want to talk about the statute, just for a second, if I could. and I know my white light's on.
It's okay,
It
go ahead.
says consent or request. Request is direct. You asked me a question, I'm trying to answer it. Maybe I don't answer it completely, but I'm trying to answer it. Request is direct.
But why I don't understand that argument, honestly. Why can't they both be direct? And I'm not saying that's how you would read them, but I don't think they're mutually different. They're necessarily different things. Because I can say to you, I want you to do this work, and that's a request. Or the tenant can say to you, I want you to do this work, and I'm there, and I say, yeah, I agree to that. That's consent. You can consent or request directly to a party.
It's consent or request.
Right, but you could do either one of those things to the
That's
contractor.
There was no request here, but there was consent. On the facts of the case, there's no question that the owner consented to the work specifically that was done by...
And in fact, the typical landlord owner, when work is going on, if the tenant is doing work that they don't want done, is going to serve a notice to cure to somehow stop that work.
In Cohen versus Paddock, the owner specifically came and objected to the work, and as a result, the contractor lost.
But the point being, I think, from the consent or request language that I thought you were making was, and maybe I just had the argument wrong, was that request was request to the contractor, consent implied consent in some type of lease language. But to me, consent or request can be direct to a contractor. It doesn't have to be consent between the landlord-tenant or a direct request to the contractor, and I thought that's how you were setting it up.
That's absolutely correct, Your Honor. And I'm saying it doesn't have to be a direct request. It can be consent based on the facts of the case, both from the lease and from what occurs during construction of the work.
Thank you, counsel.
Thank you.
Counsel? You have your 1 minute.
Now, just on this consent thing, I mean, it is vexing, I think. But in this case, okay, so Corps did look at the preliminary design drawings, but then never,
I'm sorry, go ahead.
then never saw any more drawings ever again. The contract with Ferrara and Peaches, and Mr. Ferrara testified to this, that he said the only way we'd enter into this agreement is on a time and materials basis because Charlie wanted to tweak things, change the plans.
Can I
and they
just
used
clarify, are you saying there are facts in dispute as to the conduct of the landlord? Because the lease is in writing, we can
Right,
read it.
Exactly. Well, I would say that, you know,
That's a yes or no?
I don't think, I guess there are, because he's saying...
What would those be?
Well, he says that because somebody was at the mall,
Yeah.
who wasn't inspecting work, just happened to be around to see if anybody...
But that's a disagreement about the import of
Right, but
the
okay,
person
then-
being present. Where is the factual dispute?
Then there isn't, because we didn't, Mr. Scanio consented to Mr. Ferrara's work. We didn't know what the scope was. I mean,
Is the rule you're seeking that the landlord must expressly consent to the contractor to do any specific work that the contractor bases their lien on? Is that your rule?
I think it has to be tantamount to express. Now, are
Okay,
we
what-
going to...
What makes it just short of express?
Pardon me?
What makes it just short of express when you say tantamount, which means it's not express, but it's close enough?
I think there has to be some kind of an understanding from the landlord directly to the contractor. Some kind of...
What case has said that from this court?
Not this court. Paul Mock was the first that came up with that out of the first department, and it's heavily followed.
Thank you, counsel.
Okay, thank you. Thank you for your time, Your Honor.
You're very welcome.